Are your board and C-suite aware of the full extent of your legal and regulatory responsibilities in cybersecurity? Or could there be a critical set of gaps in your knowledge? Welcome to Cyber Broadcast episode 155, where we discuss what don't you know and what should you do about it in this critical area of legal cyber education for your board and C-suite. Today we shine a light on this often overlooked area of board and C-suite cyber legal education that could be leaving your organization at risk. Many boards and C-suites, in fact, are well versed in compliance checklists, yet unaware of the nuanced legalities that could be critical in a cyber crisis and often actually are. From our conversations with the legal community, even Fortune 50 chief legal counsel are lacking in this area. So listen in. In the context of escalating cyber threats, boards and executives must deepen their legal know-how beyond the basic requirements. Take, for instance, the not so well-known legal concept of reasonable security practices. What does that mean? If a breach occurs, organizations are often scrutinized for whether they followed these practices, which are not always defined by explicit regulations, but rather by a standard that evolves with the cyber threat landscape. And unfortunately, with cybercrime growing at a minimum of 15% per year and already dwarfing every country's GDP in size except US and China, the reasonable security practices, quote unquote, definition is a constantly moving target, right? Especially exacerbated also by the cybersecurity market only growing at 9.7% per year versus the 15% cybercrime growth. That's a problem. So here's how your leadership can close this knowledge gap effectively. First, expert cyber legal workshops. What do we mean? You need to organize workshops led by cyber law experts to educate your board and C-suite on the latest legal standards and interpretations of such, quote, reasonable security practices, unquote, within your industry. For comprehensive resources in this area for your board, C-suite, and legal counsel, schedule a chat with us at cybernationcentral.com. 2. Scenario-based legal training. Engage in scenario-based training that presents real-world cyber crises, focusing on the legal decision-making required in the heat of a breach by each of your board directors and executives. 3. Regular legal briefings. Schedule briefings with your legal team and make sure that you're keeping abreast of the latest cyber legal developments, court cases, and regulatory changes that impact your fiduciary responsibilities, because as we discussed in the last episode, your fiduciary responsibilities and tactical responsibilities are now affected at an individual, not just organizational level. So you need to start paying attention to how laws and regulations are now affecting not just your organization, not just your board versus C-suite or finance team, etc., but you individually as a chief business development officer, or head of audit committee, or CFO, etc., because regulations are now shifting gear in that sense and in that way. In episode 156, we'll explore how to develop an incident response strategy that not only meets technical objectives, but also aligns with these evolving legal standards. And your board and C-suite's not only fiduciary responsibilities required for compliance, but also tactical responsibilities crucial for actual breach deterrence and incident response that protect you from worst-case scenarios. Until then, I'm Andrei Setmarsky, reminding you that in cybersecurity, ignorance of the law is no defense. So stay informed, stay compliant, and stay ahead of the curve with Cyber Broadcast by Cyber Nation Central. See you next time.